On now to the judiciary. Ghana's judiciary has, quote, a broken image. That's the opinion of former President John Dramani Mahama as he launches yet another scathing attack on the Chief Justice in Imyebwa. The Judicial Service, especially justices of the Supreme Court, have attracted a lot of backlash from the main opposition NDC after the apex courts dismissed their petition challenging the electoral victory of President Akufo-Addo in the 2020 elections. Following that and the growing calls, of course, the Chief Justice engaged the National Security Minister some months ago where there were warnings that the continuous bias rulings by some justices and judges within the judicial system is a threat to national security. Here's a recap of that report for you.
Global situation where threats are manifold and diverse. This is a critical intervention that will make all of us sleep a little better at night. I wish to take this opportunity to once again commend the Minister and the leadership of the National Security Ministry for their vision and patriotism in making this possible. Of course, the ministry alone cannot be entirely responsible for the implementation of this document. An integrated policy requires an integrated approach. In the light of this, the ministry is today seeking to engage the judiciary as necessary partners for the successful implementation of the policy. As the guardians of law and justice in our country, I believe this is the only right, and it is only right and proper that we are fully engaged in this process. Indeed, the ministry has previously engaged the Judicial Council and today represents another step in this journey of continuous engagement in the collective service of our motherland. Mr. Minister, I assure you, the judiciary will play its role as imposed on us by the Constitution. Colleagues, I do not think that I need to remind you of the critical role we play in the national security infrastructure. While the threats are in a state of constant evolution, one thing remains constant, and that is the fact that the law is one of the major tools that we have to use to combat them. The decisions that are taken by national security officials must be done in the light of what is lawful, and where there are conflicts between the rights of individuals and the security of the state, it is the courtroom that those tensions will be resolved. This is why this interaction is absolutely essential. I wish to urge you, therefore, to commit to this process wholeheartedly and to engage frankly and enthusiastically with officials from the national security. I wish to assure the minister and his team that we recognize that our partnership is of key significance to our collective survival, and we will work very closely with them to ensure the success of this new integrated national security strategy.
Well, so that was the Chief Justice then. In spite of that assurance from the Chief Justice, President John Dramani Mahama believes that the image of the court has been broken. He further stressed the need for the judiciary to work to win the trust of the citizenry and erase the widely held perception of hostility and politics in legal proceedings.
Recently, so badly has the image of our judiciary deteriorated that many of our citizenry openly make mockery of our justice system and of our justices. The phrase, "go to court," is these days met with derisive laughter instead of hope that one will truly get justice if he went to the courts. If people are not poking fun about politics and inducements being used to sway the hand of justice in the lower courts, then it is poking fun and making statements about the 7-0 of the unanimous FC. Verdicts which mostly involve cases of a political nature in our Supreme Court. This is an unfortunate but serious development. One of the scariest existential threats to any democracy is when citizens think their judiciary holds no value for them or no use to them. And this is the security threat that the national security apparatus tried to draw the attention of the nation to recently, but was poorly received by the president and his party. We'll get to a stage where people will have no qualms about taking the law into their own hands because they do not have the confidence that they can get any justice from the system. There is therefore the urgent need for the Ghanaian judiciary to work to win the trust and confidence of the citizenry and erase the widely held perception of hostility and political bias in legal proceedings at the highest courts of the land. Unfortunately, we have no hope that the current leadership of our judiciary can lead such a process of change.
Former President John Romani Mahama there. I want to bring in now Joseph Diok Penka, former Deputy Attorney General, joining us on this conversation. Thank you, sir, for your time. In fact, John Mahama was mounted at that event. In fact, the General Secretary of the National Democratic Congress, Johnson Asiru Nkitia, goes to point to how some quote-unquote NDC lawyers are being victimized and intimidated by the court. You share the same view?
Absolutely not. You see, my brother, I want to put this in perspective as I commence the discussion with you on this matter. You see, immediately you lose confidence in the judiciary or incite the public against the judiciary, the country is doomed to fail. That's my preliminary comment on this matter. I say this without a shadow of doubt because, yes, it is true that when anybody is aggrieved in the country, the person's source of justice is the judiciary. The last resort is the judiciary. And that if the judiciary cannot guarantee you justice and an expeditious one at that, and one that will indeed soothe you and assure you that when you are in difficulty and you run there, you will get what the Constitution guarantees. If you don't have that type of judiciary, it will be unfortunate indeed. But I beg to differ clearly from His Excellency, the former president, that the conclusions he drew did not actually have any fundamental basis, because I expected him to cite instances where injustice was perpetuated by the judiciary. When you make an omnibus or general statement which is not backed by concrete evidence or statistics or facts, citing particular judgments or cases in which justice was subverted to substantiate your case, but rather just relying on general statement indicting the judiciary, that would be most unfortunate. Because remember that the unanimity he's talking about, if it did happen at all, was with respect to the election petition. And I have stated that I met one or two NDC lawyers, even when the petition was ongoing, and I stated to them that they had no case at all because what they had presented to the court was nothing, and you cannot put something on nothing and expect it to stand. I stated this. And so if the justices on that occasion were unanimous, 7-0, 7-0, 7-0, what it also tells you is that your case was without merit, same died at the time it was conceived, and so it should not have gone to court in the first place. But you cannot use that as the basis to come to a general conclusion, therefore, that the image of the judiciary is dented by virtue of the fact that they gave a verdict of 7-0. First of all, this is not the first time the Supreme Court has delivered. If you go through the records, every day the Supreme Court delivers judgments. And in most of them, they are unanimous. So if there is unanimity and you have a problem with the unanimity and you expected somebody to dissent, that may be your own problem. But if you are indicting them, indict them on the basis of the decision taking, but not on the basis of the unanimity. And if you are also making a pronouncement that indicts them, cite the specific case that they ought to be indicted for taking a 7-0 decision, when in fact it ought to have been a split decision or otherwise. When you are able to cite those specific circumstances to back your case, then you may be making a very strong case for yourself.
I guess that goes way beyond, and in fact, issues of justice goes way beyond just the judgments of the Supreme Court or any justice, you agree. For instance, take a look at the Santro Kofi Akpafo Lolobi case, which we've had residents of course, expressed some doubts about the willingness of the Chief Justice to look into that case. They've not had the opportunity to vote in the parliamentary race. Justice must be seen to be delivered. Why is that not happening for some of these residents? So if you have them come up, for instance, and question the judicial system, they are right, isn't it? And this is not just John Mahama doing that. So he has some grounds to say some Ghanaians do have issues with the judicial system, isn't it?
Well, if you're talking about Santrofia, Kwafu, etc., that's another issue that you are putting on the table.
But the point is, the former president was talking about the judicial system. I guess it's not fixated on
yes,
the United
but even
cases.
that one, you have decided to specifically cite that.
Right.
But in that, is there any pronouncement from the judiciary that you think is an indictment on the judiciary with respect to...
Yeah, but the case appears to have lingered on.
There's no pronouncement.
Yes, precisely. It's delayed. And looking at how sensitive it is, the belief is that at least the judicial system would have taken that matter seriously.
But you remember also that the same Supreme Court has decided already that anytime an issue of that nature is with respect to the creation of new constituency arises, then it must take effect from the next election. You are aware, aren't you? Stare decisis. Precedent guides us as far as our legal jurisprudence is concerned. So if the Supreme Court in one state had decided that in cases like that, then it should take effect from the next election, then you may have to go for them to review it, urge on them to review or depart from their own decision. Otherwise, if you are unable to persuade them to depart from their own decision, what the earlier decision has been binds them to it. So, but the general comment about the judiciary you've spoken about, it was not specific to the election petition. I agree. But then again, that is why I'm saying that he ought to have provided further and better particulars, 3, 4, 5 examples or 6 to buttress your case and say that on the basis of this, it is enough for us to conclude that there is no longer interest by people, or our own people do not longer have interest in getting justice from the court because they have been denied same by virtue of a number of examples that I have cited. If you do that, you give us an opportunity to critique it in a manner that will question whether or not what you raised is genuine. But if you make a general statement that there is no longer, I remember that there's even part of the speech that says that we need a new Chief Justice to restore.
Yeah, precisely. I was going to come there. He says he's lost faith in this current crop of leadership at the Hub of Affairs within Ghana's judiciary.
And that is, again, unfortunate, because, again, he doesn't provide any shred of evidence to back that. You see, if we don't take care and we continue to bastardize the judiciary the way we continue to do, it may lead to contest another day. Because if tomorrow, in the unlikely event that he becomes president again, and then he decides that he's going to descend on the judiciary and etc., there will be conflict. And remember that judicial power is exercised all in conformity with Article 125 onwards, where it is vested in the judiciary and they are supposed to make a pronouncement, but they are guided by the Constitution and the fact that the citizenry ought to also participate in the dispensation of justice and etc. But I'm saying that looking at the caliber of person who was speaking, not an ordinary person. If it were any ordinary person, I'll give the person the benefit of the doubt. But once upon a time, number one gentleman of the land makes a categorical statement indicting the judiciary, it is most unfortunate. Remember that there are millions of Ghanaians who believe in him. There are millions of Ghanaians who trust in him. And when you make such a statement, it has the potential of inciting the populace against the judiciary. And when we reach that point of Armageddon, you may even want to recant whatever you said earlier, but it will be late in the day.
Well,
so
some security analysts,
caution.
Some security analysts connect this to the threat against the state. In fact, a reason for which some of them are suspecting that the National Security Minister brought together the judiciary just to express that sentiment to them. The fact that the judiciary appears to be biased in the face of, some key stakeholders, be it the main opposition National Democratic Congress. The National Security Minister does not belong to the NDC, yet he has concerns about their posture. Do you feel that this is the time we need to have more transparency within Ghana's judiciary and not necessarily have the justices cocoon themselves within the whatever provisions it is that the law is giving them immunity from?
First of all, let me throw back a fundamental question. If you put 7 justices to decide on an issue, and then their understanding of the law, all 7 of them agree with one another, is it not also within the ambit of the law? It is within the ambit of the law that 7 of them should agree. It is within the ambit of the law that some of them should dissent. And remember, recently, some of the judicial decisions, there were people who dissented. Even on the matter with respect to, I think it's central, the central region.
You mean
central.
Right.
I mean, some of the justices dissented recently. I remember that Justice Nene Amegache and one other dissented in one of the latest decisions. There have been cases where people dissent. And there is nothing wrong if all justices agree with the process because their understanding of the law has coincided. Remember that even if you look at our past, if you look at our history, I always respect the case of Kufuor and Attorney General, and I also respect so much the case of the 31st December one, in which there was a challenge whether or not we should celebrate 31st December with resources. It was a split decision. All right? I think it was 5-4 or so. And we moved on from there because they had different orientations. If you read that judgment, they had different orientations. Now, if you come to me, for example, and let me just mention this. If you come to me and you want a declaration that I should nullify a particular result, then I ask you a question. From your own calculation, how many votes did you get? And you tell me that you didn't bring that to court. What do you expect? You expect a judge to dissent to that? Simple question. From your own calculation, how many votes did you get? I didn't bring it to court.
Yeah, but I guess in terms of, and you're taking us back to the presidential case, in that case, clearly the NDC was not very much dwelling on the figures. Their argument was no one had crossed the 50% threshold or the constitutional required figure.
That was a very mischievous argument.
Yeah, but that was their case before court. It wasn't about the figures.
Again, you see, if you come asking somebody to do the right thing, how do you capitalize on the person's wrong to say that they should make a declaration in your favor? You came. The lady, when she was making the announcement, she actually indicated in categorical terms that these were the total number of votes. And she segregated it to total number of valid votes and invalid votes. But in doing the calculation, she inadvertently lumped them and arrived at what she did, in which case the NDC's argument was right. But how do you let somebody do what is wrong and you want to right the wrong with the wrong? So, I mean, whatever they presented to the court was followed. So the declaration that was made was lawful.
At least the belief is that former President John Dramani Mahama, after the fallouts of that Supreme Court ruling last year, would have moved on. But he seems to have that conviction that there's something wrong within the judicial system. What do you suspect may be the problem of the former president?
Well, he may be privy to something that I don't know. But remember that he became president about 9 years ago, also on the score of winning a Supreme Court case. And some of the current justices who are on the bench were part of that. They were part of the system that made him president in 2009. That's also a statement of fact. You see, my fear, which I want to state, is that if care is not taken, statements like this can let people lose confidence in the judiciary. And at the end, the nation will suffer. Even foreigners who intend to come and invest, when they hear statements like this from no less a person than a former president, they may become scared and stray away because they may think that if they come in here and they have a problem and they go to the judiciary, they are not going to get justice. It can scare people. That's why I'm saying he would have done us a lot of good. If he had cited quite a number of cases and instances or conduct or acts of the judiciary, commission or omission, that he found to be such that if care is not taken, people who lose interest in the judiciary and take the law into their own hands.
This is where some experts say we need a mediator. Of course, the former office you occupied is quite sensitive. The office of the, of course, Minister of Justice, constitutionally required to be advising government on some of these issues, and also to be seen as the executive arm, ensuring that there is justice within our country. What would you expect from the Attorney General in trying to just mend the faults and the concerns of the opposition party, together with what concerns it is that they may be having with the court?
Well, first of all, there's also a limit to what the Attorney General can do. The limit is that there's no way the Attorney General can interfere in the judicial affairs of the state. Because as I indicated, judicial affairs of the state, as in Article 125 of our Constitution, justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. So the Attorney General cannot interfere with justice. If he does, the law will take its own course against him. If the judiciary is subject only to the Constitution, it is not subject to any individual or group or organization or institution. So it is subject strictly only to the Constitution. And justice emanates from the people. So the Attorney General, if he finds certain things that may not be good enough in running the country in terms of law, his remedy may be to liaise with government to sponsor a bill in Parliament for it to be passed into law, to regulate things in a manner that will bring sanity and let us move on. But you cannot interfere in the judicial affair. But if you also find that the conduct of a justice has brought his office into a state of disrepute, you trigger the appropriate processes that will lead to the removal of the person if a prima facie case is established and a committee of inquiry set up finds the person culpable. So there are processes all over. But as he made that statement, you also know that every organization in this world, there's no organization that is made up of only angels. There may be a few people who may act in a manner that may bring the judiciary into a state of disrepute and etc. And most of them are made to suffer the penalty for it, dismissals and etc. I think that the former president, he has an opportunity to also use state institutions that will right the wrong where it is necessary. But general statements that you don't substantiate can lead to people actually losing interest in the judicial system. Yeah,
I guess the concern is not only stemming from the former president. General Secretary of the National Democratic Congress, Johnson Asiedu Nketia, is also raising some concerns. He says, I mean, this goes beyond the bench. He talks about the bar, for instance, where he says, even lawyers who are perceived to be aligned to the NDC are not getting jobs these days. And your government has, of course, sort of found a way of intimidating all of these lawyers. I'm sure you've heard his comments as well.
That is perfectly incorrect. I totally disagree with him. You see, lawyers, we are the group of people whose regulations are very strict. We are not allowed to do what we call touting. You don't go on social media to pontificate what a good lawyer you are. You don't go on platforms to pontificate what a good lawyer you are. If you are a good lawyer, your acts in court will draw clients to you. So we don't do that. We call it touting. If you do it, you face the disciplinary committee of the General Legal Council and all that. So if there are good lawyers in NDC, which I know there are, people will definitely hire their services. I also know some NDC lawyers who are very successful even in this regime. That is a statement of fact. So if there's a particular person who is not getting services, and it is just by virtue of the fact that he's NDC, that cannot be correct. Because remember also that there are businessmen, there are litigants, thousands of whom are NDC. Do those people take their cases to MPP lawyers? That's the other question you should ask yourself. I think no. And I know quite a number of lawyers, tens and perhaps hundreds of them, who are very successful and they are into buoyant practice, and they are NDC people. So again, that statement is not backed by any scientific evidence. And I haven't heard any MDC lawyer complain that he's not able to get services because he's NDC. I have not heard that. If you are a lawyer and do make such a complaint, it means that you are, excuse me to say, an incompetent person. If you are competent, clients will come to you and hire your services. It will not matter your political coloration.
Ordinarily, all of these comments coming on the back of that engagement would have been treated, well, with just a pinch of salt, at least knowing that it's just a normal political gathering. But this time round, we have NDC lawyers, and in fact, some of them former attorney generals joining in and listening to the former president. No dissent at all, and none of them have come out to say, well, we disagree with what our leadership is saying. So it appears that these are legal minds expressing that collective opinion through their leadership. I mean, that should be treated with some utmost concern, isn't it?
Well, they were actually professionals addressed by a politician.
Yeah, but lawyers, all lawyers.
That's what I'm saying. They were professionals addressed by a politician. Truth be told, there was no way anybody could stand up there to recant or say that what His Excellency, the former president, said was untrue. You know it. There was no way. Even if somebody will have a dissenting opinion, the person will keep it to himself or herself. No one will stand up there and speak to the former president and say that, look, for me, I'm very successful and MP. Nobody will say so. You know it, my brother. Practically, nobody will say so. So the fact that they remained silent does not mean that all of them endorsed what he said. Because I have been meeting them in court every day anyway. Very successful ones among them. I've been meeting them in court every day. They make their cases. Some of them do so well, and etc. So it is not the case that we've not been seeing them in court and they are not getting cases. If they say so, then there will be a flip of the coin to say that it may mean, therefore, that they were getting so many cases during the NDC. If they make that admission and say that when the MPP came, they are not getting, then, of course, they will also be making an endorsement to an illegality again, that when their party was in power, they were getting cases. When their party went into opposition, they are not getting cases. We shouldn't create that society at all. Any professional lawyer who is good and worth of his sort, when there is a change of government, the persons will still get a case to do because people will come to you and litigants know what they want. They want victory. They want good services. Whatever you are, whatever political coloration, if you are a good lawyer worth your salt, people will come to you, whether you are in government or in opposition.
In fact, I thought that would have been the last one, but we've not heard from you in a while. A lot has happened in the sector where you used to superintend. Of course, the Office of the Special Prosecutor has come under intense scrutiny following that, of course, first attempt to fight corruption, if we have to call it that way, by probing some issues at the Ghana Revenue Authority. We've seen the end game, the president directing, of course, the head of the Customs Division to relinquish his position. For you, is that testament of the fact that the president is indeed supportive of anti-graft agencies?
Well, first of all, I would like to say that while in office as Deputy Attorney General, I was privileged to superintend over the passage of a number of bills into law, some of which strengthened the fight against corruption. For example, the Whistleblowers Act, then we looked at the Governance Act, then we looked at the Witness Protection Bill, which also we passed into law, and we looked at the Companies Act, the New Companies Act, and several other legislation. I can tell you that not in the history of this country have we enacted anti-graft legislations that we did between the period 2017 and 2020. Not in the history of this country. So all the beautiful laws which have been enacted by our parliament to fight graft, all we need to do is to now have strong institutions and strong personalities to carry out these so that it will be done in a manner that will achieve the desired effect. Remember that you can have all these beautiful laws. If you don't have the people with the will and the wherewithal to carry these laws out in a manner that will affect society directly, they will just gather dust. And I think that the special prosecutor is one such person who is actually actualizing the law and making the law work and bite for us to have the benefit that we are supposed to actually reap. And we ought to give him thumbs up. However, everything he does is subject to law. And that is why the particular thing that has generated the furore with respect to the La Bianca matter, if you look at Section 12 of the Customs Act 2015, Act 891, for example, and then the discretionary power that are given to the customs boss to exercise when it comes to matters pertaining to the applications that were made, such as what La Bianca did. If we think as a people that it is being abused, we have to take it out of our law books. But so long as we allow it there, it will be exercised in conjunction with Article 296 of our Constitution, where discretionary power is vested in the person who is supposed to exercise it. So people with discretion will exercise it anyway, but it must fall squarely within the remits of Article 296 and the way it is couched. If it is outside that, it's unlawful. So if we think that the exercise of that power by the Commissioner General of SEPS, for example, is being abused over the period and ought to be checked, then Parliament will have to review that portion and take it out of the law. But so long as it remains there, it will be exercised.
The belief is the president is not acting in good faith, knowing that this is bad timing. Of course, the name and the reputation of the colonel retired is on the line. He's expressed that fear himself. And in fact, we've heard from former Special Prosecutor Martin Amidu come out to say the reputation of these persons indicted in the report is on the line. And then we have the order from the president asking him to hand over. He may never have that opportunity to clear his name, you agree?
And challenge it. Whatever report the Special Prosecutor has is not sacrosanct. You know, it is subject to judicial challenge. You can go to the High Court and challenge the findings. If it makes acts of criminality against you, and you can challenge it in a competent court. And if you so adduce evidence to that effect, it will be struck down, and it will even serve as a kind of star decisis or precedent for us to follow as a people. So the fight is not over. I have listened to all the parties in the matter. I've heard them in the media, and etc. I've read about the matter, and I think that the best way to go in this matter is for us to go to court for a proper application of that law, and we know the remits and the parameters within which that law operates.
Yeah, but you don't feel the president has not been fair. You don't feel the president has not been fair to Colonel Damon. This is someone whose term had expired, yet the president held on for close to a year. So why not allow the dust to settle? So at least we know what it is that's going on there at the Ghana Revenue Authority. You're basically dismissing him before his time.
Well, I don't even think the word dismissal is accurate.
Okay, not renewing his contract, right?
Absolutely, because you see, to say he's dismissed means that he still has the mandate, his contract is still running, and then you terminated
right,
it.
Right.
This particular case, his contract has expired.
Yeah, but the timing is wrong, right?
I will not renew it. The timing, you see, what again is a discretion His Excellency the President has exercised. And remember that he is the chief executive, and all of us who are appointees or persons who are appointees of peace ought to act in a manner that will meet his expectation, or he can exercise his discretion at any time to remove, and he doesn't have to assign any reason. And in any case, in this particular case, he hasn't indicted him. He hasn't said that on the basis of the ongoing investigations, I find that you are culpable, therefore you are removed. He hasn't said so. But I think the good colonel can go to court and fight the matter and get a judicial pronouncement that will put finality to this issue, so that it will serve as a guide to future commissioners.
The OSP, vote of confidence from your side? You believe in him?
I said from the very day he was appointed, I was fortunately on your powerful forum. I was privileged to be part of Joy program when he was appointed, and I made categorical statements that he was a mate of mine in the first degree in NACO, and I knew him to be a very tough person, very principled and very intelligent. And I said that I was not going to be surprised that he was going to chalk successes and come out very strong, and he will make a very good case for the young generation. I said it, and I have not regretted. I know that he is going to meet a lot of challenges, but at the end, if he remains focused and is committed to his work, he will triumph, and his name will be written in gold many years after he has left that office.
Okay then, Joe, we have to leave it here. Thank you for your time.
I'm grateful, my brother.
On The Pulse.